Yes. 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 Just wait. Yes. Huh? Just wait. Time I will give it. Put it. Short bit. Yes. What is the impugned order? Put it. Yes. Not nada. Short bit. You serve the other sides. Whoever the other side. No, it's converted into a CRP. So what happened to the CRP? Tomorrow. You intimate the other side. Intimate the other side. Good. I'll come back. 20th. It's there on 25th. Monday. Yes. Check. Yes. They have fortunately managed to get the water for the summer. And now they using that. Monday. Good. Not yes. Just on page wise.
Page number 1, page number 11, page number 2.
Bill number 15. To inform the other side. Inform. List the matter on Monday. Yes.
Page number 3, 23. Page number 4, 4 to 13.
You inform the other side. I inform and then you report to the court of. Yes.
Page number 5, 31 to 34. Page number 6, 35 to 42. Page number 7, 43 to 45. Page number 8, 46 to 48. Do 308. I'm not 208. I'm not in Narayana. I'm agenda.
Next week and order okay, let us see. I'll take note of it. We'll get the file and see what is to do. Afterwards, at 4:30, you just find out. At 4:30, you just find out.
Number 9, 41. Page number 10, 54 to 60. 11, 61 to 58.
That request made on behalf of the respondent. List the matter next week. Yes. You take out notice. Take out notice. If you notice to the respondent, same one. No, correct. No, so now we have to, he has to come and then we have to see, isn't it? Correct. I know. Now we have to pass an order after the notice to the other side. There is one judgment, 1 or 2 judgments on the point saying that the court, if granting liberty, must with permission, otherwise dismiss the application. Just have a look at that judgment and keep it ready. Serve on the other side and move the matter. You should know. Yes.
Number 2.
Just get those judgments next time.
I did.
You take out notice. Let's issue notice, same order. Yes.
The extent of the was sold 1,140 square feet in excess. Therefore, by mutual mistake, not the double size was the so that is have to be rectified. So the process of the court. By application for appointment of the commission to with the court and take a measurement what exactly is in excess of what is the sold. But the learning that I did not dismiss my application. So the ground rate I want to plan. Plan would have
Take out notice. But that application may amount to collection of evidence.
The extent, what is the thinking of the mind of the party? What is the extent of the soul? What is the extent? Here, language is just for the extent. But now, it is noticed that the excess of 1,400 not inside. Not inside, what is people have to do? Equal extent soul.
Issue notice in light of the submission contentions raised that what has been conveyed was the excess extent, though the same is not reflected in the sale deed, which has necessitated filing the application for appointment of commissioner. Subject to further consideration, there will be stay of the proceeding for the trial court in the next date, same order. Yes, yes, yes.
Appearing on the petition, this matter, my lords.
No.
Serial number 4.
You take out notice.
No, here, what has happened here is, my lords, the issue has already been decided. Lord, I will take just 2 minutes, my lords. The mother of the respondent had filed a suit for recovery, which was pending. And during the pendency of the suit, she passed away. And Lordship can see IA number 2, page number 27, ILC, annexure C, my lords. IA number 2, page number 27, my lords, where a LR application was filed. In page number 28, Lordship can see at para 4 of the affidavit, para 4, I submit that I am the only son of the plaintiff and I am the legal heir to the deceased. It came to be allowed. And subsequently, Lordship can see there is a IAF number 6, my lords, it's at page number 30, filed by some other people stating that they are the legal heirs, which came to be rejected, my lords. Lordship can see the order at page number 37. The suit is of the year 2000. Now these applicants came before the court seeking to implement them as defendant number 2 and 3 by contending that they have also shared in the suit claim. Since 2011, the applicants kept quiet, and in this belated stage, this application is moved. Evidently, the suit is only for the relief of recovery of money, and this is not for relief of partition and suit claim. If at all the proposed defendants have any claim over the suit claim, they have to get the redress remedy in a separate proceedings and not the suit. This application is barred by limitation. It appears that this application is moved only to prolong the litigation indefinitely at the stage set for indefinitely at the stage set for further cross-examination. Appealable even as last chance. Therefore, it is considered view of the court that this application is devoid of merits. The same is liable to be rejected. Therefore, the following IA number 6 is rejected. The same people, my lords, So it has become final. They have not filed any appeal. It has become final. Now Lordship can turn to page number 40, my lords, which is the part of the impugned order.
But let us see what is the reason why the court has passed such an order.
No, Lordship can turn to page number 40, my lords, for a moment. By
I've seen that order. Let us
what has become
notice.
final? They have not filed any appeal and it has become final. And now the other judge wants them to bring those people on record, which is going to prolong it only.
No, but there must be some reason the court had posted the matter for judgment and then has passed order exercising suo motu powers and order 1 rule
There
10.
was some I don't want to say anything, some miscommunication, my lords. After passing the order, even the learned judge felt like that. He was not aware of this one or whatever in the earlier order.
Let us see.
Number 6.
You take out notice, you serve the trial court counsel and move the matter, we'll consider.
It is posted for Monday, my lords.
Let us see, let notice go.
Monday, if it is not there, if I have to bring them on record, that's why. Lordship may give me. Lordship, it is the extent of this order only. Let the trial go on. I am the defendant there. Let the trial go on. I am ready for the trial.
Let us see why court has exercised that power under order 1 rule 10. It's a suo motu exercise of power. So let us hear the other side and then decide. You take out notice.
No, to the extent that let it not be pressed, my lords, this order. The only limited order can Lordship may give me.
Let us see after. Let notice go.
Otherwise, Monday, if I don't bring them on record, then I will be in trouble. That's why, my lords.
No, you take out notice.
I will take out notice, my lords, because 23rd the matter is posted. Tomorrow, day after tomorrow is second Saturday. So Monday only it will come up.
Nothing
so that's why I'm asking for a very basic order. I'm not asking for the stay of proceedings, nothing, my lords. Only regarding this order of impleading.
Let the impleading process go on. You have to still take out notice to the impleading applicants.
No, my lords. No. There is no impleading application. The order is passed with suo motu, my lords. There is no impleading application. The impleading application is rejected already.
Let notice go on that. Let the proposed persons come. We'll hear and then decide. It's an exercise of suo motu power. Unless I hear the other.
No, they are not as such. They are not parties to the proceedings in the OS, my lords.
That will issue notice. Same order. No, the only question is normally in impleading applications. One line of judgment thing, the test is whether the court can pass a judgment in the absence of that party or not. You are saying that you had made some complaints against him and there may have been.
Now, my lord,
and then gave up.
Then sought to not press it against him. Actually, from these offices, public media house. My not brought next to the coverage in the university player,
Later. Yes, in light of the contention raised, that it is at the instance of the petitioner that certain media reports were made as against the plaintiff before the trial court, and that on an earlier occasion, petitioner was impleaded as a defendant, but only subsequently deleted. It is contended that the trial court has erred in rejecting the application for impleading the petition. Subject to further consideration, there will be stay of proceedings before the trial court, same order. But you just examine one legal position. The test, some of the tests are that it's for the court to decide whether decree could be passed or not. So if it's only a suit for injunction and whether it amounts to violation of his privacy or not, is something to be demonstrated by the plaintiff. Whether you are a necessary party, that legal position you. Yes. They're not necessary insofar as no. Notice to respondents. Two to 35 is dispensed with at the risk of the petitioner. Yes, but the larger question which has to be seen in all these suits is simply blanket orders are being passed in all matters on the very first day. Is passed and then it gets lost.
Without examination, without the other side being heard, it is before passing such blanket orders. Hearing should be done.
And whether that balancing of rights also must be looked into.
Because nobody is denying privacy. There are issues. Whether those acts really took place, then it is also a public good. There is an exception to the definition of public good. Then it is not defamation. In such cases,
That has to be examined now. At the asking, in all matters, injunction is being given left, right, and center. Yes. Yes, you take out notice. Well, let us hear, we'll have it on Tuesday. You serve the other side and we'll hear the matter. Now the trial court has stated that you had admitted in evidence that you are not in possession. And only subsequently amendment application has been filed seeking for recovery of possession. See, huh?
the right had not been able to be shared. Therefore, even when a wrong position had aspect of the agreement, not just not meaning policy aspect of the agreement. From that, and the position had then grandfather did not have the right under the agreement, whether it right to deliver the position. Even when this amendment is not
We'll have it on Tuesday. Serve the other side and notify. Let us issue notice, same order. List the matter on Tuesday. Yes. Yes. Other side to the Counterpart you can take. This is the matter in the preliminary hearing. Yes. No, but you have also filed a suit. Appeal. Appeal. There's an appeal pending, isn't it?
That is the partition. Yes, that partition RSA has been filed. RSA is pending or of 20. That is with regard to the partition. Here, my lord, is the requirement number 1 obtains the review for the farming. Here is my lord, responded not P5 execution petition. The execution petition, we file an application on part of 21A, getting that we responded to also executed an agreement in our favor. We have also filed a suit performance. But that came to be decreed by order and I have produced that judgment from
Yours is a subsequent decree.
subsequent decree.
Which was the first one now?
First one is
That that is decree holder.
no.
The
First decree holder will be execution.
that is OS.
Case number 203 of 2015.
203 of 2015.
I mean, 116 of 2007.
That is your suit. 116 of.
2007.
Now this OS 203 of 2015 was decreed earlier. What is the? But then why? What has happened? Why yours?
They remain as. In fact, we have been putting for it. According to not that person, we have been determined in the application.
Now, why didn't you seek for a clubbing of both this? You came to know only later. No, your suit was there. 116 of 2007. 2000.
I was decreed in June 2020.
OS 203 was decreed on. Now the other suit is OS 116 of 2017. When you're not aware of this OS 203.
We came when we came to know, we filed an application. The court should have determined one question have been determined.
No, but which is the earlier agreement?
Our that agreement, they are playing not 2012.
When is your agreement?
18/3/2014.
Then you are subsequent. Then how you think?
That should we have been in possession. Any order now we pass to for enforcement of the decree. That was not in possession. That should have been determined. Now we other try to reject the application without the document was. Order 21 rule 58 contemplates determination.
Correct, but now finally, at the most, you will have to join in the execution of the decree.
That is the question, my lord. It has to be determined on that. It has been dismissed because earlier one more suit was partition. RSA is pending.
You take out notice.
No, executing or decree or
Yeah, yes, you are still whatever rights you have under 116 will still be available to you. Prima facie or a subsequent agreement.
that also question. No, I cannot.
No, but eventually what finding you can get? As is a subsequent agreement.
You have been made as a party, cannot be one of the.
You know, take out notice, we'll have it next.
You are in possession.
Let us see. Let us see.
For limited period.
No, so let's see now. Let them issue delivery warrant against it. Let's see. Now you serve and we'll have it next week. We'll take up the matter. No, let it move till that stage. Let us.
Only one condition. Without conducting inquiry, straight away doesn't manage it.
Correct. Let us see. But if there is a.
Before that, read or something like that, further from another. Again, you should understand the outcome.
No, now sale deed will have to be executed. We are the subsequent.
We have one without possession.
We'll have it next week. You take out and you serve the counsel appearing before the trial court. Let us see. Nothing will happen still. No, let us see. Let us see. Let them come. We'll see. We'll hear them. If after hearing them any case is made out, we'll stay the process.
Please, madam, may one more till appearance. Till that date, madam.
She notes. On merits, there's nothing.
Something can be worked out.
I'll execute a decree. Issue notice to the respondents. It is the submission of made on behalf of the petitioner that without adjudicating his claim in light of he being a party in OS 116 of 2017, impugned order has been passed by passing a cryptic order. There would be a stay of execution proceedings for a period of 3 weeks. Yes, take out notice. It is your suit. This is a amendment application was filed before trial.
Yes.
Yes. Issue notice to the respondents. It is a case of the plaintiff that the application for amendment was filed before commencement of trial, and court ought to have been liberal in considering the application which has been dismissed. In light of the submission made and contention raised with the stay of proceeding before the trial court till the next date, same order. Yes. Yes. Now you take out. Huh? Yes.
The amendment of the amended claim for trial. It's any property which are sought to be included after the trial or property belonging to some other person. There was
Okay.
And now may not get to go to someone after trial.
So that will.
They are including some property and then this is one matter.
Let us see. Let us see. No, the court has said that certain additional properties Now, that will, correct.
No, if that person is included, person has been included, amount to denote.
So the trial will go on for some time. You take out notice, we'll have it.
One, this is because it's end of the day, and where is the same.
Let us see, let the written statement.
Government can you see what is the order pass? I don't know the after the.
No, the court says that there are additional properties. So since there can't be a partial partition, those properties may be necessary.
So properties should belong to the party to the.
That let them file the written statement. Let us see. Now you file. That will say that you want to file additional written statement pending further consideration will permit you to file. You file and you participate. We'll have it week after next. Let the other side come. We'll hear and then we'll dispose it. That liberty I'll give you if you want. If they're not giving you sufficient. No, let us see.
Persons not included, and his property be partitioned and his right to be declared.
So
You want the property, how to put it as an incorporated after the completion of trial.
correct. No, the order I agree with you is sloppy. I agree with you.
It is stupid, madam.
I agree with you.
Clearly, madam,
No, that
therefore, the present applications are allowed. Present applications are allowed with after recording this, we are the amendment. Then now we know
I'll direct the trial court to permit you to file additional written statement. No. Then so any proceedings would be subject to the outcome of the writ petition. We'll hear the other side and see what is to be done. The petitioner submits that additional written statement was not filed subsequent to the amendment, as the petitioner had intended to challenge the order before this. In the beginning. Challenge the order before this court. It is clarified that the petitioner be permitted to file his additional written statement without prejudice to contentions taken in the present petition. It is further clarified that the proceeding before the trial court would be subject to outcome of the present petition. Issue notice, same order. You move the matter as soon as you serve the other side. Yes. When do you want it? This is the matter on 20th. Yes.
Impleading why so
Paragraph.
What is the argument of
Correct. Now, how are you going to balance the interest of
there are 8 properties. Only one property. Only
whether he can sell, a person can sell more beyond the extent he has. That let us see, you take out notice. You take out notice. Please. You should notice to the respondents. You serve and then you move the matter. No, even if what will happen, let us see. The proceedings of the trial court will be subject to orders to be passed in the present petition. Yes.
Number 11.
Yes. Yes, you take out notice. Issue notice. Same order. Yes. Date. 31st. ಬರ್ತಾರೆ ನೋಡೋಣ. Correct. Now the trial court has said you have not examined the attesting witness to the will.
Yeah.
Huh? No, but then you could. No, but
based on only clear.
no, but then you'll have to seek for reopening of that stage. Now here, you only challenge this subsequent order. But now let this be pending. Meanwhile, you seek for reopening of that stage. Now the application has been rejected. The inquiry was only partially completed, according to you. You are not given a full opportunity. So what I'm saying, let this be pending, this writ. Meanwhile, you also file a writ challenging the order whereby your request for adjournment was refused, saying no further evidence. That order you challenge. That order you challenge along with this, and then you produce, in case attesting witness is ready, 50. So what I'm saying, that this order of 1110, this order you challenge and club it along with this writ petition to show your bona fides, if it's a registered will or not unregistered. Okay, let us see.
My submission. They insert in higher court, they insert that. So that is the reason I am rejecting the application. Now what happens? Now they are executing petition. The review order is already going to execute the review. They are succeeded in executing.
Let us,
15 days or 20 days. By that time, I will file another.
let us see, we'll hear the other side. You serve the counsel appearing before the trial court, we'll have it next week. Like them counterpart Hede, let him serve. We'll take out hand summons also. And then you move the matter. I'll make it clear that, correct. I'll make, no, I'll make it subject to the outcome of this writ. I'll make it clear that any proceeding before the trial court is subject to the outcome of the present writ petition. Issue notice to the respondents. It's clarified that any proceedings before in the execution proceedings are subject to the outcome of the writ petition. Yes. Same order. Yes. To the Indian matter. Indian matter ಬಂದಿದೆ. We are waiting for you.
Was fine. But not good property as before, not responding.
No, sir. Now you take out notice because let us see. You take out notice. Serve the counsel. No, what will happen? No, correct. What will happen now? Huh?
Then I tried to shoot one of the cancellation of the JLE. Again, you are not including the pregnancy of the suit. Second defendant has solved it to the present respond. Now I made an application to not bring the record. The court says that not since this relation is there made.
Dispend.
Pregnancy of that is amount of dispend. These two contested response, the defendants are more interested or no. Because of the same. Only not the purchaser has to come on that. Otherwise, not again the amount to multiple proceedings. When an execution is made, not again they will file an application under media for
Issue notice to the respondents in light of the contention raised, including that the defendant number 4 has lost interest in defending the proceedings in light of the alienation made. There would be stay of further proceedings till the next date, same order. Defendant number 4 has sold it.
Yes, sir. Yes, sir. Defendant number 4 has sold it to not the defendant number.
No, to this applicant. No, D4 has sold it to this a person who you sought to implead, isn't it? Yes. Yes. Now you take out notice. No, correct. You lead evidence. Finally, the grievance of your grievance is it should have been decided as a preliminary issue. Nothing will happen. What will happen? Correct. Correct. Now you take out notice, let the proceedings progress, you serve and then, let us see. Let us see. Let us, let us see. No, what I'm saying, that let the proceedings go on. You serve the other side, move the matter, let us see. Let the suit progress for whatever it is worth. Issue note. No, let us see if the, no, that's okay, but let there be, no, let us, nothing will happen. Nothing will happen. Issue notice to the respondents. Yes, you serve and then move the matter. Yes.
Meaning by pleadings. First, let's speak upon the one. Immediately after here, then you will not learn that after, I mean, there was a loan loss. The agreement we had paid for 11.5 balance we had paid the bank itself. Here, 25,000. After that, after perform, he not do it, we issue the note. After we issue the note, we issue the we have paid the matter was about to conclude at that time we have learned that in the everything and it's deep. Hence we can see the model of operation. We were putting into that years ago. Then another loan was taken. Now we got another agreement was internet. Hence we find the applications impeding of that. Don't even issuing notice.
Maybe the court felt anyhow that person will be bound.
It goes to that person, he may be also alerted, he may not proceed with the matter. And that way he got another decision, that will go on.
We may have to join in the execution of the sale deed. No, but he's only an agreement holder.
This agreement is not substantial payment to be made. And he has cleared that loan with the second all these things are bank. Unfortunately, bank is also party. It's not ordered to they have received money and
Correct, but I'm saying now if your suit is decreed, everybody, including him, this person will be bound.
that's true. Sufficient here. But to our record, that would make him also alert. We don't know whether he is aware of it. He is also being due in you come tomorrow. He is a proper part, not the necessary part. Proper part.
So he's only an agreement holder.
Registered agreement. Entire payment,
No,
complete payment. Is
correct.
paid.
Now suit for specific performance.
Yes.
Now suit will be decreed because the owner is a party.
Yes.
Now this person who is seeking to implead is a registered agreement holder, no doubt. But that does not create any interest in his favor legally speaking. In civil law, agreement agree. So what I'm saying is, you take out notice to that proposed impleading applicant. Let the proceedings in the suit progress. You take a judgment.
don't know. That is why.
No, we'll issue notice. No, we'll issue notice.
In that, because the notice was ordered.
So you have not made. No, you are him as a party. Here, I'll permit you to amend. And you take out notice to him.
Then,
You may get you may get a decree by then. Huh?
Until then, until that time, only till next day, maybe 2 weeks, I will serve.
No, it is your suit. So that's a
Knowing that.
no, that will say, but I'm saying strictly speaking is not a necessary part.
It's proper.
No, how
Not necessary. I consider.
agreement holder in civil law, there's no creation of rights in an agreement holder. You'll have to deal with him.
My concerns are twofold. Only, they've been deceiving me. Because I am also a victim and another person is a victim now.
No, that's all equity. Legally, it may not be necessary. The petitioner is permitted to. Petitioner is permitted. The petitioner is permitted to implead Bhagyavanti, wife of Praveen Kumar, as an additional respondent. It is submitted that during the pendency of the suit, fresh rights are created in favor of Bhagyavanti, which would act to the prejudice of the plaintiff and render it difficult for execution of decree in execution proceedings. Subject to further consideration, noticing petition is filed by the plaintiff, there would be stay of further proceedings before the trial court. Same order. No, but in law, so that you just see. Yes, yes. On 20. Page number. Yes. $39. Yes. Then it was advanced.
That is on photo like file application.
So you're saying there's no argument of plaintiff, no defendant post of a judgment.
Order sheet dated 24/11. And order sheet dated 9/4/2020. 100,000 from the plaintiff 6 and they are rejected. Review the records or judgment. According to I
And even you have not participated properly. You have also not led the evidence. Huh? No, further evidence of plaintiff is taken as nil. Page 38. Huh. No, now application is filed for recall of PW1. Now we will allow the applications. Huh? Correct. Correct. Hmm. So now as on date, there is no evidence of defendant. As on date, there is no evidence of defendant. So let there be some reworking of the procedure. So we'll allow this recalling, subject yourself, and then we'll see. Let us see. Let it go on merits. Now we will record his undertaking that he will. That is there. But when is that? When everything is finished. Here nothing is finished. No evidence of defendant. No arguments of defendant. Even if you take the last order to be correct, matter and plaintiff has not given advanced argument, matter should have been posted for defendant's arguments before posting it for judgment on 24/11. You are also not present. Look at page 41. No representation by plaintiff. No representation, a matter is called passed over. No representation by plaintiff. Later, plaintiff counsel is present. Let us see, there is let him come on merits. Then you do it. He has filed his written statement, isn't it? You want to lead further evidence? I'll provide it once and for all, even that opportunity. Not after he recalls, then again. But that's how the judges should be. Otherwise, you will not.
Yeah, I think actually, But I would rejected the same, posted it as a.
So now what you do, you find out whether you want to lead further evidence, because otherwise then again one other IA, and if the court rejects, you will come here. You find out whether after you had recalled yourself for further evidence on IA number 4, whether you want to lead any further evidence. In this order only, I'll make a reference to that also. You find out if you want to lead further. Huh? The petitioner was into defendant 2 to 5 before the trial court has filed the present petition seeking for now you appear for all. You are the plaintiff, isn't it? Seeking to set aside orders passed on IA number 5 and 6, invoice 1 of 2017, whereby the trial court has rejected the application filed seeking for reopening of the case and permitting the defendants to cross-examine TW1. Just read from para 8. Just read. Yes, page 42. Page 42.
The main primary case is that public must so that what to put the law change. The trustee established public purpose to be and effective work for establishment at the regulation and one school under the A1 style of Eastern International Pre-Primary School by offering necessary provision to lead the development of is a person who has I, or the court and the draft of the judges of the defendant of all, that must else be decided to have take control over the entire administration of trust by determining the state of trust or right of the clearly trust.
Yes. Peruse the impugned order as well as the order sheet. It is noticed that the plaintiff had also sought for leading of further evidence and application filed by the plaintiff, IA number 4, isn't it? IA number 4 was allowed. However, it is noticed that subsequently, as plaintiff had sought for time, the evidence of further evidence of plaintiff was taken as nil. Thereafter, it is noticed that the matter was posted for defendant's evidence on 10/11/2022. On 10/11/2022, as defendant was not present, the evidence of defendant was taken as nil and matter was posted for arguments on merits on 24/11/2022. On 24/11/2022, plaintiff had sought for time and matter was adjourned finally to 9/12/2022. On 9/12/2022, the request of plaintiff for time was rejected. The trial court perused the records and posted the matter for judgment. It is noticed that the matter was posted for defendant's evidence on 10/11/2022, and on that date, in light of absence of the defendant, matter was right away posted for arguments. The contention of counsel for the petitioner that there was no sufficient opportunity for the defendant requires acceptance. Next, it is noticed also that even on 24/11/2022, the trial court notes that plaintiff had sought for time, which prayer was rejected, and then after perusing records, has posted the matter for judgment, which may also not have been a correct procedure that was followed. Next, it is noticed that though the learned judge has submitted that question of reopening the matter once it's posted for judgment did not arise, the perusal of the order sheet would indicate that no sufficient opportunity has been granted by the court to the parties. It would be necessary to afford an opportunity to the defendants to participate in the proceedings. Accordingly, I find that the trial court has proceeded on the merits of the case, and no doubt there may have been some lapse on behalf of the parties by taking adjournments, but the perusal of the order sheet would indicate that the court ought to have given further opportunities to the parties. Accordingly, taking note that no reasons are assigned as regards to the dismissal of the application on its merits. It's a fit case for setting aside the impugned order. Matter is remitted back to the trial court. Applications are allowed. The section D, IA 5 and 6. Accordingly, IA 5 and 6 are allowed. The case stage of the case is reopened for the purpose of cross-examination of PW1. And PW1 is recalled. It is also to be observed at this stage that as request was earlier made by the plaintiff for further evidence, in the event plaintiff wants to plead further evidence, liberty is reserved to the plaintiff to do so in light of the order recalling PW1. Thereafter, the defendant is at liberty to cross-examine and proceed with the matter. Both sides undertake that they would not seek unnecessary administrative, applicable administrative order relating to disposal of old matter. Really, Martin. Just make a mention that we have disposed it of. Yes. Yes. So this was evidence on additional documents. Light of the contentions raised, subject to further consideration, there would be stay of further proceedings in RA 30 of 20 in the next date. Issue notice to the respondents. Petitioners permitted to serve counsel appearing for the respondents in the regular appeal, and is also permitted to take out notice by way of handsome at the same order. Yes. Pass over. Pass over. No, you take out notice now. 1 minute, just come in. You take out notice. It's a IA is passed, MA is also passed, isn't it? So you take out notice, serve him, and then we'll issue notice, same order. ಇದರಲ್ಲಿ RA ಅಂತ ಹೇಳಿ MA issue notice, same order, man. Yes. Yes. I have forgotten, so you'll have to start. Now, what is the instructions? Huh?
Conflicting player they are asking. Yeah.
Huh?
Yeah, yeah. Is there an action?
No, you tell me the facts. You read the order first.
Is not sleeping under the
Page. Okay, now you application is filed by you. You just take me to your IA. What is page 67? Yes.
The registered GPA related. Registered stated related. Okay, tenant are not timing. What is the they are not. Again, there are visited Lakshmana before I cannot accept one is the concern Milagro. These tenants and the GP are concerned.
4/3/2011 and 10/6/2011 relate to item number 1. Yes.
Before Milagro, there is a conflicting of where they are asking. Firstly, they are not paying anything. Thereafter, Milagro accept.
Let us see what is it. What is this? The petitioner has purchased through sale deed. And 10/6/2011. Now sale deed was executed by children of Lakshmana. Children.
Other parties here.
Now, what is the effect of this amendment?
Initially, they are.
Let us see. I'll come. But your government is not clear what it's. What do you? No, that is there. But then what do you mean by Lakshmana has equal right in all the suit scheduled properties except in 1 and 3? So what is the meaning of that sentence? But that amendment is not clear. If that is clear, then we can allow it. They also have no objection to it. Either you say that sale deed is proper, but that sentence, deceased Lakshmana has equal right in all scheduled properties except in 1 and 3 is not clear. No, otherwise I reserve liberty for you to withdraw this and file another application. If he is going to support you, let us see. So that we'll say, but I'm saying that amendment also is not clear. That amendment, proposed amendment is also not clear. So that's why, unless he clarifies, otherwise you withdraw that IA and you file fresh IA. You file? No, correct, but now so that how I can clarify. That no, so I'm saying then you take benefit of that amendment if it amounts to giving up their rights. So let the amendment be there. Otherwise, I will send it back for reconsideration. I'll reserve liberty for you to. Then you take instruction whether you want this IA at all, or you want to, because the amendment is not very clear. That's all. Let him withdraw this. I'll record that. And let him then, I'll record his undertaking. He wants to withdraw, set aside the impugned order, and reserve liberty for him to file fresh. There, if he is going to make some admission in your favor, you take benefit. It is the petitioner has challenged the order passed by the trial court on IA 43 and 46. By orders dated 1/7/2019 and 20th/7/2019. There are two IAs, is it? It is seen that it is seen that IA 46 has been filed to review the order passed on 1/7/2019 on IA 43. Insofar as order on IA 43, it is noticed that the trial court has disposed of the application for amendment filed by the fifth defendant by an order. Where is that typed copy of that order? Page? By an order on which only records heard satisfied with grounds, IA 43 is allowed. That is the order, isn't it? It is after hearing the matter for some time, learned counsel for the petitioner submits that the para 9 has two averments, one relating to not binding of sale deeds dated 4/3/2011 and 10/6/2011, and the other part relating to the statement that inverted comma that deceased Lakshmana has equal right in all suit scheduled properties except item 1 and 3. It submitted that if it is a clear statement that the defendants have no claim in item number 1 property, they would have no objection for the amendment. It is submitted that there is some ambiguity in the governments of para 9E. After hearing the matter for some time, learned counsel for the respondent submits that they may be permitted to withdraw the application, reserving liberty to file fresh application in light of certain ambiguities that are noticed in the proposed amendment. Accordingly, the even otherwise, noticing that the order on IA 43 is a cryptic non-speaking order. The impugned order passed on IA 43 is set aside and matters remitted to the trial court in light of the undertaking made by the fifth defendant to seek for withdrawal of the amendment application. The liberty is reserved to the fifth defendant to seek for withdrawal of IA number 43. Upon orders being passed on the same, it is open to the fifth defendant to file fresh amendment application if circumstances are so made out. In light of passing of this order, the order on IA 46 is also set aside. Accordingly, matter is disposed of. Noticing that the suit of 2006 suit to be disposed of, keeping in mind the applicable administrative direction as regards disposal of old matters. Yes. If it is required, you make, otherwise just go ahead with it. Yes. Means earlier there was an amendment. Now let us see if he is going to give up his claim in so far as item number 1 is concerned by fresh. You take benefit of. Let him see. You find out what he is. That is them. Yes. With office objection. With office objection. So what is the value according to you? Page? Item 1 according to you is? That is your valuation. How much they have offered? And the other item? How much they have offered? And then we'll ask some reasonable escalation and then close the procedure.
Is present, my lord. And it is actually, my lord, an approved valuer's report. That basis, and we have approved the sale deed as well, present sale deed during that time. And the guidance value required. And also we have submitted. Based on that only, my lord, the honorable court considered. But at that time they were silent, my lord. My lord, my client is ready to give some additional for the amount. Because my lord, this property, my lord, there was a lessee, and that amount, my lord, that has been fully paid by the number 1, and got the tenant vacated with the help of the any taking any share. Now, my lord, she's ready to give one man another 50,000.
Yes.
That stage has crossed. That stage has crossed. Correct. Afterwards, she filed an application. So, correct. But after that, they filed and they're entitled to place their offer. Court has accepted it. Now the proceedings are at the fag end. But you are not ready to buy. You are not in a position to buy. Correct. So they are entitled to buy. And because, no, but,
It's a dwelling house.
what, you are residing,
House residence.
you're residing there.
Residence. Dwelling house.
No, but they're still residing there. They're purchasing the portion in their possession and something beyond that. You know, that is again joint family property. So how much you can? 50,000 is too less. Make some substantial increase and we'll just close them up.
Well, that is actually mirrored share of this petitioner. It comes around 32 lakhs and 50,000 as per the approved valuers report. And we have deposited the entire amount before the court long back. Whatever
Deposited.
we have deposited.
Deposited.
Complete amount we have deposited.
When was that deposited?
My 11/10/2009 by the lakh 20,000, that is the last payment.
11/10?
7/9/2019, right?
7?
Sorry, it is 9/9/2019, 11 lakhs. And 11/10/2019, 10 lakhs 20,000. And another 11 lakhs.
So more than 2 years since you made the deposit. Because he will close it. I'll ask him to make some additional deposit and you increase in both for both the items. You make 2 lakhs, increase your.
In one item, I am purchasing only one item. Respond number 3 has sought for buying the item number 1 property.
Which item you are?
Item number 2.
Item number 2. Item number 2, what is your valuation?
64 lakhs.
64 lakhs. That 49 lakhs you have offered.
That is the respond number 3 has proposed to.
This is yours is
Item number 2.
1 crore 15 lakhs.
That is no they are saying. But actually the approved valuers report including the building. It was 64 lakhs.
How much you have offered?
It was 32 lakhs and 20,000 is the share of this petition. That amount we have deposited.
32 lakhs.
32 lakhs and 20,000.
Pay another 1 lakh and close them. The petitioners. Just read that impugned order. Yes, partition partition.
Impugned order is dated 7/9/19.
Yes, yes.
7/9/19. The 7/9/19 order is the petitioner counsel filed memo along with 2 ready for 11 lakh each cash grants to verify the same and send it clearer. The R3 file counsel file grace time to remaining deposit, initial and new counsel present to deposit the remaining balance. Respond number counsel filed application under section 51 of CPC, seeking permission to conduct public auction sale. Third, respective counsels and considering the orders passed on 19/19 and 10/4/2019, application filed by R2 is not only belated, but infructuous and repeated balance by 11/10. Filed memo with the TD, filed by the respond number 3, office to receive the same and clearance.
You have typed copy or you have? Page?
Page number 174, 173.
the petitioner you are the respondent in the execution proceedings. The petitioners claiming under respondent number 2 in the FDP proceedings have filed the present petition and seek for setting aside of the order passed on an application filed under 151 of CPC dated 7/9/2019, whereby the trial court has rejected the application filed to conduct a public auction. It is to be noticed that the trial court, by its order of 7/9/2019, has rejected the application filed by respondent number 2 in the final decree proceedings, seeking for conducting of public auction. Where is that IA? IA is that page? The respondent number 2 submitted that on an earlier occasion, the petitioner in the FDP proceedings had filed IA number 3 seeking to take out public auction / sale of the petition scheduled property, which was allowed on 8/6/2015. It is submitted that it is only recently that the other co-sharers who are respondent 1, 2, and 3, 1 to 4. You represent 1 to 4, isn't it?
Represent 1 and 2. In this case, respond number 1 and 2. That is mother and the son.
Who appears for the other 2? But now the challenge is mainly as regards 1 and 2.
Mainly, yes, sir.
Because you have submitted your offer for this
This year.
this year.
This year, item number 2.
Recently that the other court or respondents.
Respondents 1 and 2. One and 2, and the other also wanted to have made
Respond number 3
and
is
4.
by the item number 1.
4.
Item 4 mirrored.
Okay, now insofar as respondent 1 and 2, you have made your claim to purchase item number 2, and respondent number 3.
Respond number 3 mirrored item number 1.
Item number 1. In particular.
Recently that or respondent.
1 and 2 have filed an application seeking to purchase item number 2, and respondent number 3 has sought to purchase item number 1, and said applications have been allowed. He submitted that the valuation made by the said respondents is not up to the market value. And that if the property is put for public auction, it would fetch a better price. Now you filed objections? No, only oral objections.
On that day itself, because earlier it has become infectious, the Honorable Court immediately passed the law.
Now who appears for the third respondent here?
Engaging the service of the advocate. Today,
Is not there. Full stop. It is submitted by learned counsel appearing on behalf of respondent 1 and 2 that the application filed is at a belated stage when proceedings have already advanced. I'll mail one sentence, Mari. Parties are referred to as per the ranks before the executing court for the purpose of convenience. Learned counsel appearing for respondent 1 and 2 further contends that the commissioner was appointed for carving out the shares at an earlier point of time and had arrived at a conclusion that was not feasible and practicable to divide the property. It is further submitted that it is no doubt true that application was filed at an earlier point of time seeking to sell the property by public auction. But subsequently, the respondents filed an application under Order 21, Rule 72, as also the third respondent seeking permission to buy 3/4 share in item 2. That is filed by you, isn't it?
1/4 belong to the respondent number 3. And since she took my share, it has been set off. That quarter share is set off between the respondent number 3 and this respondent number 1.
Okay, let it. Seeking, but the application is to buy 3/4 share. 3/4 share in item number 2. Full stop. It is submitted that respondent number 3 also had filed an application seeking to purchase certain shares in exercise of right under Section 3 of the Partition Act. Full stop. The said applications came to be allowed as per the order dated 19/2/2019. You have a copy of that order? Page 75. Could you? Where is the order? You have the order copy. Page 75. The page 75, just check. The trial court has disposed of the said application filed by respondent number 1 and 2 as well as respondent number 3. It is submitted that this, correct, some review you file. Correct, so page 75 is the order. Page 75.
Order sheet in my order sheet. 90.
You have give it
It is page number 171.
171.
170.
No, but before the trial court, you are respondent 1 and 2, isn't it? So your application, the court doesn't refer here.
The application was filed earlier.
Hmm.
It's actually on 91 to 2019. It's a page number 168.
Correct. Subsequently, it was reviewed according to you.
The review order is on 19. It is at page number 171.
IA6 is allowed, filed by R3. But yours, I don't know what.
A6 is allowed by allowing my review. I read the computer.
No, but where is the reference to your?
There is a second part. R3 by IA under the P of the petitioner the order review. The petitioner has review petition along with citation. To amend the part.
The petitioner is your respondent 2 and 3.
Respondent 1 and 2. Petitioner is the petitioner in FD is respondent number 1 and 2 here.
You are the petitioner.
Petitioner.
Yes. Yes.
Petitioner to amend the constitution are wanted. Their LLs are already on record as per 8/2030. Order passed. And also, as an order sheet dated 17/8/12, R5 is no more, and here no LL. First it amended. In view of death of R1 and 5, first petitioner and the respondent 3 are entitled to share. R3 present, R2 and 4 represented, not filed any objection, nor prosecuted. Also, produced commissioner report dated 17/3/15. The then commissioner has submitted his report stating that property is not capable of division. Commissioner has agreed to purchase the item number 2, and R3 is also purchasing item number 1. And in view of the review petition, and also application filed by R3, main petition was to buy the share of R2 to 4, and R3 has no objection in this regard. Considering that provision of the section Partition Act, IA6 and IA5 by R3 is allowed. They are permitted to purchase the share of other sharers value determined by this code. fixed value of the item number 1 and 2 of the property. Both petitioner and are some sub-register valuation and also copy of recent sale deed executed in and around the property by 1/3. Issue both notice to RTA or for the interest of justice.
Rank of party and chain of
The IA number 6 and IA filed by R. The IA 6 filed by me.
IA6 is filed by you.
IA 6 and IA filed by R3 0.
Next. It is only one star actually. Rank of parties to be verified. Next. Notification. It is to be noticed that the petitioners in the FDP proceedings had earlier filed IA under Order 21 Rule 72 seeking to purchase share of respondents, which however came to be rejected by order passed on 19/1/2019. Subsequently, it is submitted that the petitioners had in the FDP proceedings had sought for review of the said order passed. In the meanwhile, R3 in the FDP proceedings had also filed application under Section 3 of the Partition Act, read with Order 21 Rule 72. Both the applications on 19/2/2019, the review filed by the petitioners as regards the order on IA number 6, as well as application filed by R3 under Section 3 of the Partition Act came to be allowed. By virtue of the review, IA6 came to be reconsidered and allowed. Accordingly, the respondent number 3, as well as the petitioners in the FTP proceedings, were permitted to purchase item number 1 and 2 respectively. Matter was set out for fixing of valuation of item 1 and 2. And the court, by order of 10/4/2019, has recorded that the valuation made by the petitioner appears to be reasonable after considering documents filed in support of the said valuation. And the court has proceeded to fix the valuation. Subsequent to the said order, the petitioner in the FDP proceedings has made a deposit of amount of 7 lakhs on 7/9/2019 . And it is only on thereafter, on the said date, an application came to be filed by the respondent number 2 seeking for public auction. The court in the execution proceedings has rightly dismissed the application while noticing that there have been subsequent orders passed on 19/2/2019 as well as 10/4/2019. Learned counsel for the in the FDP proceedings submits that the valuation submitted is on the lower side. However, it is to be noticed that the right of a co-sharer to purchase shares of the other sharers by virtue of provisions of the Partition Act, the settled position of law, and in accordance with which application has been filed and disposed of by the executing court by permitting the respondent 1 and 2 as well as respondent number 3 from purchasing item 2 and item 1 respectively. The said orders have been passed to 2019 and have not been challenged. At this length of time, after more than 3 years, application was filed on 6 months. After 6 months, application was filed seeking for conducting of public auction. No challenge has been made to the earlier order granting permission respondents to purchase the shares. That not have, it is not open for consideration of the present application filed. Accordingly, though the order is a cryptic order, we are this court is in agreement with the conclusion, and accordingly, no ground is made out for interference. Learned counsel for appeal. Upon instructions of respondent 1 and 2, submits that they would increase their offer amount by 1 lakh. Same submission is taken note of. Accordingly, matter is disposed of, subject to the above observations. Page. Page. Yes. Fifteen, 12, 22. 15, 11. Yes. No, that is amongst you all. You sit and sort it out. Correct. Hmm. Otherwise, let it be sold in the open market. That is there. But according to the market value is 3 crore 81 lakhs. Then let it be sold only. Then let them take 25, you take 75%. There ends the matter. No, otherwise. Correct. Otherwise, both of you carry out a joint advertisement. If offers come, then you can see. Then you place any buyer. Suppose there is any buyer, you place it before him. And if it is so that you are going to get 5 crores or 6 crores, then divide it in the same profit. So I'll have it after 4 weeks. Both of you sit and invite offers. And in case there is something, you can divide it in the same profit. List the matter after 2 weeks. If there's any buyer, you date. 6th. Yes. Interim order earlier grant is extended till the next. No, in OS 387. Your parties, is it? Take me to the cost title of the suit. Annexure C is order sheet of the miscellaneous proceedings.
Each day of the operation, how the High Court has gone past and stating that because High Court has I have not found it, there is no execution. And therefore, I cannot say 6 days of execution. That are not solved.
No, read the order. Let us have a look at the order. Yes.
Thereafter, they are right. After the lapse of hence is the execution in this finally, there is a color the petitioner by name. File a suit. In the opposition, there is no therefore, staying of execution. Area of one of the defendants, and he has also gotten share. Right. My career that the reasons given that this one in the operations reasons that the reasons that his order on this particular idea is that I have not execution degree is not escaped. I have not been forced. Secondly, the reason is given.
Now you take out notice.
In the next one.
Correct. You serve it and move the matter next week. Let us.
Yes.
We'll see what it is. Suit of 96. And your father, is it Ramaya? Was a party in that suit. Then how now you can and suit for partition.
Their file is to partition as a petition. My contention which are associated. This is my practical. Everybody made Ramaya and so we treat it completely. They are not there.
No, but then Ramaya has participated in the proceedings.
Ramaya is participated. My mention in that they didn't even know that.
No, correct. If that were to be so, you'll have to challenge the judgment and decree by way of an appeal, not in these.
These proceedings are they are whatever this all of this.
That we'll see. You take out notice. Same order. Yes, yes. ಅದು ಸೇಮ್ ಆರ್ಡರ್ ಅಂದ್ರೆ ಅಲ್ಲಿ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದೀನಿ ಚೈಲ್ಡ್ ಕೋರ್ಟ್ ಅದು ಕೊಡಿ ಒಂದು ಫಾರ್ಮ್ ಎಸ್ ಎಸ್ How much time both of you will take? By 3:30? 3:30?
I can do it.
Those tomorrow? I bench it. Huh? I bench it. And tomorrow?
4 o'clock, right? Yes, right. Subject to lunch. Of course, we will both be able to finish. Or also, not some matters are there. Or not.
Because, huh? No, but it will not, then it will spill over. You take a chance some, because till Monday election petition, I don't have Monday election petition starts. So then in any of the intervening days when there is nothing, no election petition we can take.
You get more. You get more than that.
But I don't want to break it up to start. Next week. What is the Let us see, the election petition is coming to an end, sort of. We'll have it on 30th. 30th,
31st for subject.
31st. Yes. The synopsis, dates and events filed on behalf of advocate for respondent number 1, along with memo of citation, is taken on record. You have already filed. The council, the petitioners also have filed. Also state they have filed their synopsis. Yes, release the matter on 31st. First. Yes. Thank you. They had sought for time at 10:30. They had sought for time. Respondent. Yes. No, you are the purchaser or what? Your purchase.
There are numbers connected.
Now, what is the trial court? IA numbers 7 and 8. No. Now, if you are not a party in the proceedings, you are at liberty to seek for substantive relief in a fresh suit. Correct. Now the court has rejected. Now you are at liberty to claim your rights regarding the not binding of the partition suit because you are not a party. No. What is your? Let us have a look at it. Now you are claiming to have right in survey number 166. How have you? You have purchased this or how? Page number? on 17/7/2008. No, but the suit was of the year 99. So your subsequent purchase. Then, no, according to you, this your vendor has nothing to do with that family. It's a different source of title, and they have wrongly included this property as belonging to them. Correct. Now, in light of the dismissal of your impeding application, then you will have to seek for a substantive relief regarding non-binding of these proceedings and take appropriate action to protect your interest. Now, OS 2169 is filed by you. Huh? So you also will have to file your separate suit and seek for substantive relief. No, so you will have to seek in those proceedings. You can't in these proceedings because now you are not claiming to any of the legal representatives also. You are claiming an independent right. What you have filed any obstructor application you filed then? No, correct. You file an obstructor application if it is not. Under order 21 rule 97 you file. If you have an independent interest, I will give you liberty to file your obstructor application. You file before the court and have it adjudicated. Now they can file an obstructor application and then no, correct. They are saying that their property is a part of the partition property and that if they have any correct. So that as an obstructor under order 21 rule 97, he will have to be heard. Let him place forth whatever his case. There must be an inquiry and a decision. Suppose what he says to be true. He is saying that this property was not belonging to that joint family is what he's saying. And that he has purchased it from somebody else. Correct, but CPC could. No, let him place it before the court, let the court hear and decide. Now, if he has got any independent interest and is not bound by the proceedings. No. In the same only, in order 21 rule 97, it will have to be decided here. He is not claiming through any one of them. So he is entitled to make an application as an obstructor. Look at this, AIR 1998. AIR 1998. Supreme Court 1827. Third party in possession of property claiming independent right could resist such decree by seeking adjudication of his objections under order 21 rule 97. So you check the legal position and come, and then I'll give you liberty, either order 21 rule 97 or separate suit, you find out what is your remedy and you come back. According to me, it must be under order 21 rule 97. Examine that and come, and then you reserve liberty and I'll dispose it. When do you want it? Monday. You also examine whether it is in this under order 21 or a suit. According to me, it must be done in the same proceedings. Otherwise, it will result in multiplicity of proceedings. Relist the matter on first. Huh? No, so then otherwise you file before an obstructor application only. We'll have it on Monday. 24th is the case. No, so what is the stage in the execution process? Then Monday you can come. Otherwise, you undertake not to seek for deferment for a week's time, and I'll fix a date. You get ready. It's a question of law. Now, don't look at the dates. Now you take your time. Examine the position of law. Prima facie, according to me, under order 21 rule 97, he can file which has to be decided. That you also examine. If that is the position, let him, we'll reserve liberty for him to file under order 20. So then we'll have it on Monday. You find out what the correct legal remedy and you submit. I'll record that and reserve liberty. Relist the matter on Monday. Find out whether it's a fresh suit or the order 21. Yes. Page. Now, what about the other respondents? Six, 8, 9. Learned counsel so and so undertakes to file wakalat for respondent 6, 8, 9, 10, 11, and 12. Then who remains? Who are the other respondents? Who is a contesting respondent in the present writ? Now you appear for whom? Your colleague. Now what has been challenged? You are the plaintiff. Who is 75 of 98? Just take me to your application. Before that, you read the order. Let us read the impugned order. IA 44 and 47. Yes.
He wanted to correct the process of the he stated the proposal amendments. Adjudication of the matter and not really.
Now what? No, he's saying that the compromise was amended in the year 2022, and then he wants to amend it only to that extent.
Now the treaty is many.
No, they're saying the compromise decree was amended only after recent.
Compromise decree, he knows that. Ministers also knows that. In the last examination, we pass. Examination in India.
That you show that. Put it.
And the reason.
Just read the paragraph.
After.
This is the affidavit.
He knows that all this. And moreover, he is saying now that extension is immediately admitted in the process. How he is saying that amended. So you don't know the exact rulings. Unless you wait for the ruling. There are no similar. How in the year?
Now, what is the amendment now to the compromise? Let us have a look at that. Next year. Now your the extent is changed from 10 acres, 18 guntas. Now this
Then after is that that's a difference. Secondly, our government is the engine. More cases.
Now this compromise has been entered into between whom? Who are the parties to the compromise?
Just put the degree I have shown the schedule at the boundary. Now you can there are.
Now his suit is on the basis of the property that came by way of compromise. His suit, just
My friends.
yes. No, now you'll have your opportunity. If it is if compromise has been amended and he has filed the suit on the basis of the compromise, then he must be permitted to amend it.
Yes. This compromise.
Correct. And change the boundaries. Just wait. Just
Purposefully, you this same process. Not to be included in the 1998 after the concluding of my evidence, as examination completed, other side class. Minority of the cases, then they have found. Saying that, recently we have amended. Even though they have.
now, what is the amendment now? Only reduction of the extent one, and then what is the other amendment?
Boundaries.
What change in the bound? Let us listen. Just take me to your amendment application. Page
Page number 106.
You take me to your amendment application. One amendment is extent, and then eastern boundary, western boundary. Now you take me to the original boundary, let us. Page. Yes. So east by Patel. Instead of that, Patel and Gujaraya. Okay, west by Muttaya. So now land of Gujaraya instead of Muttaya. West, south by Irappa. All the boundaries are changed. All the boundaries are changed. Let us see. What is the stage of the suit?
Well, this also one amendment has been here. Amendment application. Yeah, there have been, reputation also. Same thing, again, amendment is also.
Let us see. Let us see. Now we have to hear the other respondents. You ask them to file wakalat. Now let the proceedings be stayed till then. Learned counsel for the respondent 6, 8, 9, 10, 11 and 12 submits that they would make submission before the trial court seeking for an adjournment. Such submission is taken note of. The other respondent can I please notice office to put up a report regarding notice to the other respondents. List the matter. Yeah. Is the first time it's coming or what? Issue notice to the other respondents. Petitioners permitted to serve the counsel appearing for the respondents before the trial court. List the matter week after next date. That I've observed. Allah, that I've observed that he'll seek for an adjournment. Serial number? At 2:30, make a mention at 2:30. 2:30. 55. We list the matter in the same stage on. No. On 1st of February. Interim order earlier grant is extended to the next date.
My lord, may I make one submission, my lord?
Yes,
Serial number 64, other side.
just wait, just wait, just. Yes. More rest. More rest. Huh? Or depends it's correct, but you were tagal like this. Date code. First of February. Let us. Earlier direction not to precipitate the matter before the trial court is extended till the next date. Today was the earliest date.
I'm ready, but my friends are ready.
Let us see. Let us. Yes. Yes. Yes.
My lord, serial number 64.
Yes.
Morning,
Yes.
respondent has moved a date, my lord. Interim order is operating. Interim order may be extended, my lord.
Yes, it will be extended.
Much problem, my lord.
You appear for the petitioner. You inform the other side because they have taken a date. You inform the other side and inform the court officer. 2 weeks time granted for necessary compliance. Yeah.
Court officer, sir. Sir, ಇಲ್ಲ 64 ಅದೊಂದು ಇಂಟ್ರಿ ಮಾಡೋ ಒಂದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಹೇಳಬೇಕು.
Extension ಆಗಿದೆ ಸರ್, ಆಗಿದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಎಸ್ ಸರ್.
ಬೆಳಿಗ್ಗೆ ಆಗಿದೆ.
ಅಂದೆ ಅದೆಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಹಾಕು 150 ಅನ್ನೋದೇ ನೋಡೋಣ ಅಂತ ಅಂದ್ರು.
ಜಜ್ಮೆಂಟ್ ಐತೆ
ಐತೆ ಅಂದ್ರು. ಅದಕ್ಕೆ ನೋಡ್ಬಿಟ್ಟು ಹಾಕೋದು ಮಾಡೋದು ಇಲ್ಲ ಅಂತ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಅದನ್ನೇ ಏನಂತ ಹೇಳ್ಬೇಕು, ಸೂಟ್ ಹಾಕೋದ್ ದೊಡ್ಡದಲ್ಲ.
ಅವರು ಯಾಕಂದ್ರೆ ಇಲ್ಲಮ್ಮ ಇಲ್ಲಮ್ಮ ಹಂಗಲ್ಲಮ್ಮ ದುಡ್ಡು ಯಾರು ಫ್ರೀ ಅಂತ ನನಗ
Yeah,
Yes. No.
Yeah. Let us go.
Monday will have. Monday. Modern, we'll hear it. And then we'll have to see. Some order, right or wrong, some order was passed. No, that's we'll on next date we'll hear. You are prepare also a synopsis. Yes. You also prepare any synopsis. Learned counsel for the respondent seeks for an adjournment. While undertaking that on the next date of hearing, you would be ready to go ahead with the matter. Accordingly, list the matter Monday. The interim order earlier granted is extended till the next day. Serial number? Correct. The mediation agreement you have enclosed. The mediation report has been placed before the court. Both parties submit that the matter be disposed of as settled in terms of the memorandum of settlement entered into between the parties and recorded in the memorandum of settlement under section 89 of CPC. The parties are not required, they are there. Accordingly, matter is disposed of while noticing that the dispute in OS 5242 of 2016 is also settled by virtue of the memorandum of settlement placed before this court by the Bangalore Mediation Center. Accordingly, matter is disposed of. Procedure. Memorandum of settlement. Only party sign. Noted the contents of the letter dated 17/1/2023. In light of the above, further time is extended by till 21/1/2023 for disposal of the suit. Literal ಕೇಳಿರ್ತಾರೆ. ಅದು ಒಂದ್ಸತಿ ಕೇಳ್ಬಿಡೋದು ಫೋನ್. ಸೆಕೆಂಡ್ ಲೆಟರ್ ಕೇಳಿದ್ರೆ ಬರೀ 21/1. ಒಂದ್ಸತಿ ಫೋನ್ ಮಾಡಿ ಕೇಳ್ಬಿಟ್ಟು ಆಫೀಸರ್ ಕೇಳ್ಬಿಟ್ಟು notice to respondent 5 is dispensed with at the risk of the petitioner. Interim order earlier granted is extended till the next date. List the matter in B group. Yes. Only one respondent, is it? Yeah, what date?
17.
27? No. It is noticed that there has been service of notice as per the postal track report. Accordingly, the notice as regards the respondent is held to be sufficient. Respondent to be shown as served in the causes. What is IA you have challenged? Hmm. Yes, read. No, read the whole thing, small or. No, correct. Now you tell me, what is the reason for your application? What is, just take me to your application. What is the proposed amendment like this? No, but regarding this will, you were aware earlier, isn't it? No, correct. But why you didn't seek for setting aside of the will? Is denied. Denied the will. Page?
Page 18, paragraph number 9 of. Paragraph number 6. Not aware of the death of the dead, nothing might have moved.
Paragraph?
18. Regarding paragraph 6 of the allegation, that the stipulated is not aware of the death and said as they have so called not aware of document as
So you had, in your plaint, you had sought for injunction on the basis of the will. Now only in light of the denial by the defendant, you wanted to seek for declaration. What is the other IE? That has been rejected. Nothing comes from that. Nothing comes out from that.
So
without the will. Nothing is said regarding the Indian part.
Where is your IA for leading evidence of the attesting witness?
Page 23.
Sometimes judges get up on the wrong side. This must be one such day where he must have got irritated for whatever reason and decided I have to dispose of. Yes, the ಅದರಲ್ಲಿ shown in the cause list ಅಂತ ಏನು ಬೇಡ ಅಷ್ಟೇ ಅಂತ ಹೇಳ್ಬೋದು. And as ಅದರಲ್ಲಿ and as notice has been served on 27/3/21 and no steps have been taken to engage a counsel. Matter is proceeded with. ಅದು ಇದ್ರಲ್ಲೇ ಹೇಳ್ಬಿಡೋದ ಫೈನಲ್. The petitioner the petitioners who are plaintiffs 1, A, B and C have filed the present suit seeking for setting aside of the order at annexure G, whereby application filed under 151 of CPC for leading evidence of the attesting witness. By recalling the order dated 21/12/2019, numbered as IA number 11, has been rejected, and by the same impugned order, application filed by the plaintiffs seeking for amendment of the plaint governments, including the prayer seeking relief of declaration, has been rejected. Parties are referred to by the ranks before the trial court. The admitted facts relevant for the purpose of disposal of the present writ petition is that the suit was filed by the plaintiffs against the defendant initially for permanent injunction, restraining the defendants from interfering with the suit schedule property. It is noticed from the averments of the plaintiff. Where is that averment regarding the will in the plaint? No. Averment of the plaint at para 6, that Narsimaya by his will had bequeathed the property in favor of the plaintiff. Next. Paragraph 5. It is noticed that the defendant, however, in his written statement, has denied the validity of the will in terms of the averments made in paragraph
7 of the written statement.
paragraph 7 of the written statement. It is submitted that when the matter was at the stage of cross-examination of DW1, application came to be filed seeking for amendment of the plaint The plaintiff had sought for including para 8A to include the averments relating to the will dated 10/2/1990 and has sought for including para AA in the prior column, seeking for a declaration to declare that the suit scheduled property was bequeathed in favor of the plaintiffs by husband of defendant by virtue of the will dated 10/2/1990. It was objected to or no objection? Objection. Where are the objections?
34.
You said application for amendment was resisted by the defendant on the ground that the application was filed belatedly after cross-examination of plaintiff, and that governments regarding the will were already present in the plaint, and no reasons are assigned for allowing the application. Next, the trial judge by a cryptic order has rejected the application without sufficient legal reasons, legally acceptable reasons assigned for rejecting the application. Admittedly, plaintiff has pleaded regarding the will executed by Narasimhaya, in light of the denial of the will in the written statement. Plaintiff has sought for an additional relief on the premise of the same set of facts pleaded in the plaint. First up, plaintiff has sought for a declaration as regards his title on the basis of the will. As rightly contended by counsel for the plaintiff, that in light of the denial, it has become necessary to incorporate the relief of declaration. And that is necessary in order to resolve the controversy on hand. Accordingly, taking note of the said position, application for amendment was required to be allowed. The trial judge has not assigned any reasons for rejecting the amendment application. The amendment sought for being on the basis of the same set of facts will not amount to changing the nature of the suit, as only an additional relief on the same set of facts is sought for by the proposed amendment. Accordingly, the impugned order is set aside and application IA number 11 is IA number 12 is allowed. Next, insofar as application file IA number 11 for permitting the plaintiff to adduce further evidence by examining the attesting witness of the will. It must be noted that in light of the amendment now permitted, it would be necessary to allow the application and afford an opportunity to examine the attesting witness. Even otherwise, even if it were a suit for injunction, when the plaintiff had relied on the will, it would be necessary to afford all available legal opportunity to permit adducing of evidence of the attesting witness, without which proof of the will would be in jeopardy. Accordingly, the said application is also allowed, and the interim and the impugned order is set aside. Accordingly, petition is disposed of.
Even money.
Read the order. Read the order. Read the order. Order of the trial. Page. Page 40. Read. There's a High Court direction. ಏನ್ ಮಾಡ್ತೀರಾ ಕೇಸ್ ಎಕ್ಸ್ಪೈರ್ ಆಗಲ್ಲ. Where is the IE? Page IE. Forty. The petitioner Correct. So what is this order? Earlier, by the other defendants. So the same witness is now sought to be recalled. Now PW1 was ordered to be recalled in that writ petition. Now present writ PW1 only. After this order, they have not yet cross-examination of PW1. The plaintiffs have sought for setting aside of the order dated 5/2/2021. Whereby the trial court has rejected IA 28 filed by the defendant 10 and 11 to recall PW1 and permit cross-examination, and has also rejected IA 29 seeking for reopening of the case for the purpose of cross-examining PW1. After hearing the matter for some time, third counsel for the respondent submits that the impugned order may be set aside while imposing exemplary cost, and that PW1 would be kept present on the next date of hearing, and the defendants be directed to complete the cross-examination on that day itself. Third counsel for the petitioner submits that by virtue of the order passed in WP 2590 of 2021, disposed of on 10th June 2022, the order dated 2/2/2021 was set aside and PW1 has been recalled. It is also submitted that PW1 is still to be cross-examined. Let us see it. Next, taking note of the application and the reasons assigned, and in light of stand of the respondent, it is appropriate to set aside the impugned order and afford another opportunity to the defendants to cross-examine PW1. No doubt the trial court has referred to the direction of this court for early disposal, but taking note of the submission made in support of the application by counsel for the petitioner, impugned order is set aside. IA 28 and 29 are allowed. The stage of the case is reopened. PW1 is recalled, and the defendants are permitted to cross-examine PW1. In light of the undertaking of counsel for the respondent, PW1 to be kept present on the next date of hearing, and the petitioner defendants would complete the cross-examination on such date. However, court is reserved with the liberty to adjourn the matter if circumstances so require that cross-examination requires to be continued on another date. Cost he has deposited. So how much cost you'll pay? No. Cost of 5,000 to be paid to the respondents. Yes.
Appear for petitioner, my lord.
Just 1 minute. Respondents. Service completed.
Service is completed, my lord.
No, just 1 minute. Just 1 minute. We are in the previous matter. Previous matter. Office objections relating to raised on the wakalat is overruled. ಎಲ್ಲರೂ ಸರ್ವ್ ಆಗಿದೆ.
Rupesh B, 32.
Appear for petitioner, my lord.
Yes.
My lord, respondent number 28, my lord, reported to be death, my lord. I have filed a memo to treat others respondent as their LRs, my lord. Officers, my lord, raised objection that I have to amend, my lord. I will amend within 2 days, my lord. My lord, application filed by the respondent number, my lord, 24 to my lord 32.
No, whether we have passed order on that to treat the LRs.
It's already passed, my last occasion. It was already passed.
Then you should have carried out you should carry out the amendment.
My lord, I within 2 days, my lord, would carry out the amendment.
What? Huh? Now, what is the main matter?
My lord, the application filed by the my lord, the respondent number 24 to 32 for impleading in the suit, my lord, came to be allowed. That application is, my lord, challenged for the Sanbook code. And I have filed myself as the plaintiffs have filed an application to, my lord, hold inquiry as per order 22 rule 5. Reduced section 151 came to be, my lord, dismissed. To, my lord, inquire into the fact that whether these persons are LRs of so and so, my lord. My lord, in the impleading application filed by the impleading
take me to the impugned order.
My lord, and impugned order found at, my lord, page number 68, annexure G.
You're ready. You're ready. Page
Number 68, my lord. 74 in the reasoning, my lord. Though, my lord, applicants have not assigned any reason why they have to come on record in their application, and only on the basis of, my lord, earlier suit filed by the legal heirs of the plaintiffs, my lord, this court has come to the conclusion that, my lord, they are necessary. 74, my lord, page number 74.
Yes.
Reasoning, my lord. May I read, my lord?
Yes.
The discussion on these 2 points may overlap. As such, they are taken together for common decision to avoid repetition. The principal contention raised by the applicants are that they are the absolute owners and possession of suit item number 4, 5, and 8, 10, and 11 of the plain schedule. As such, they are standing in their names in public records. Another important contention taken by them is that earlier suit in OS number 220/1996 in respect of present suit properties was filed by Siddhappa before the learned civil judge and JMFC Hidiur for declaration of title against them has been dismissed on merits, but plaintiff in collusion with the defendants without impleading has filed this suit for partition and separate possession. Since they are inherited in the subject matter of the suit, as such, they are prayed to allow them to come on record as defendant number 24 to 28 in the interest of justice. On the contrary, the claim of the plaintiff and defendant is based on the succession under Hindu section Mitakshara law, since they are claiming through common ancestor late Gangappa. According to them, applicant are strangers to the schedule to the family of the suit properties. Among the 5 applicants, one Basuraju has deposed as PW1 and produced 7 documents as exhibit P1 to P7. During the pendency of the suit, the original Sakappa died. As such, among his legal heirs, one Tippeswamy has deposed as RW1 and produced 55 documents. As per R1 to R55, the oral evidence of PW1 and RW1 is a consolence with respect of the rival claims made out in the application. The document produced by the applicant and genealogical tree, certified copies of the judgment and decree passed in OS number 220/1996 on the file of the Learned Civil Judge and JMMC Hiriur. Certified of the judgment passed in RA number 150/2005 on the file of the Honorable Additional Chitradurga. 2 RTCs. The plaintiff have relied on 2 power of attorneys, genealogical tree, mutation extract, certified copies of the 2 sale deeds. Numerous RTGs in respect of suit properties, encumbrance certificate, cash and the certificate of their ancestors, including the 1 cottage. Several voter list, certified copies of the order passed by the revenue authorities, voters ID card, Aadhaar card, license and construction of lavatory and the documentary related to grant of monetary benefit for construction. Of course, PW1, applicant number 1, and RW1 have been cross-examined at length by the learned counsel representing the rival parties. The bone contention between the parties about relationship of Kotaji with late Gangappa, through whom both the parties are agitating the claim. The plaintiff have contended that said Kotaji was the wife of late Gangappa, whereas the applicants have contended that she was the daughter and natural sister of late Nanjappa Nayak and Siddhappa. The death certificate of Kotaji, as per exhibit R27, a perusal of document is appears that said woman has died on 23/8/1945 at Hoskere, Kandali of Hiriur Taluk. Further, it depicts that she is shown as wife of late Gangappa. A careful scrutiny of the documents would suggest that it has been prepared on 5/5/2016. However, a perusal of the certified copies of the judgment and decree passed in OS number 210/96 on the file of the learned civil judge and JMC Hiriur, it is evident that said suit was filed by father of the defendant number 1, the defendant number 9, father of the defendant number 1 and defendant number 9, father of defendant number 13 to 17, and father of defendant number 21 to 23 of the suit against the applicant herein. In the suit, though legal status of Kotaji was not directly in issue, however, PW1 of the suit who deposed for himself and on behalf of a plaintiff of the suit was specifically asked to
So now the earlier order will not come in the way of the court deciding subsequently of who's the persons who are.
Milad, earlier suit was filed by Milad, few legal heirs of Milad, the ancestors Milad. Therefore, the suit was came to be dismissed, holding that Milad, you have to implead all the persons. Gangappa's Milad legal heirs have filed, few legal heirs, lefting the Milad plaintiff Milad. Now, plaintiff Milad, along with the defendants, the present suit is filed Milad for partition Milad. These
Now you have come up on which IA?
Milad, impleading application.
What about order 22 rule 5?
Adunno, ಎರಡನ್ನು challenge.
No, but you are only the applicant and order 1 rule 10.
No, I am not the applicant, Milad. I am the plaintiff, Milad. The application kept to be allowed.
Now, application under order 22 rule 5 is filed for seeking inquiry as regards LRs of.
Milad, to inquire into the impleading of whether impleading applicants are LRs of Milad Kotaji. The impleading applicants Milad claim under Kotaji Milad. Therefore, that application came to be filed. Milad praying the honorable trial court to inquire into the matter whether they are LRs of legal heirs of Kotaji or not.
Applicants claim and who else claim?
Applicants, my lord.
No, no, correct.
Annexure D.
Who are the others who are claiming?
My lord, plaintiff and defendant number 1 to 22, my lord.
But that is a matter of to be decided finally in the suit.
But my lord, to implead them, whether they are necessary parties or not, my lord, that has to be decided.
No, no, now the impleading application
Yes, my lord. Is allowed.
is allowed.
Yes, my lord.
We will say that the finding in the order will not come in the way of deciding the legal, who are the actual legal heirs of Kotaji during the suit trial.
During
We'll
the
say it
trial.
will not be conclusive. There ends the matter.
Yes, man. That can be done.
Now, whatever finding that is recorded, we will only say that in light of the rival claims that are made out, the finding given while allowing the IA will not come in the way of recording a detailed finding after trial.
And trial court may refuse to frame preliminary issue in this regard, my lord.
Preliminary issue, it can be considered along with the main. It requires evidence also.
Yes, ma'am. That can be done. But without influencing by the order passed by the earlier suit, because we are not parties, and in the present application.
Yes.
In the earlier suit, we are also not parties. Plaintiffs are not parties.
Just one. Yes. You appear for the defendants. No. Who appears for the impleading applicant? You are the impleading.
And other defendants are there. This is it. Operating against the same set of documents. And in that, what they are taking as one of is actually there are three people. One is Niranjananda, second one is Sitara, and Dr.
No, but they are saying they are not parties in the earlier suit.
They are parties. We are also parties. Yes. And our properties are excluded.
The relationship of Kotaji is also. What do you say? Was 220 you are a party?
Page number 76, my lord. Page number 76.
No, you have a copy of the judgment.
Illa.
Good. There is a finding regarding the.
My lord, page number 76 ಅಲ್ಲಿ ಕೊನೆಯಲ್ಲಿ 2 ಲೈನ್ ಇಂದ ಬರೆದಿದ್ದಾರೆ.
No, correct.
Evident that suit was filed by father.
You go into the main suit. Don't read this order. Go into the main judgment and decree.
ಅದು ಕಾಪಿ ಇಲ್ಲ.
All the parties are there. In the present suit are there. And then you also have a look at this and come. Have a look at both the RA and the OS.
Yes,
and then you come. Have a look at it and come next. This is the matter. Week after next. Now, already a finding is recorded, then there ends the matter. How we can reopen it once.
Milad, in that suit, Milad, I think since all the parties are not, partition was not sought.
No, that you see, that is a different matter. But you look at the findings in that and then you come back.
A date may be fixed, my lord. Otherwise,
Week
30
after
please,
next.
my lord, date may be fixed.
Date. Week's time granted to do the needful. Petitioners also permitted to serve counsel appearing for the respondent before the trial court. Court notice. No, wait, no. Without service, how I can hear you? See, you have not paid process. No, you check. No covers are given. No. There's no. Just see what the office notes. No, that there's no covers. You have not given covers, postal covers. Order for me.
ಕೇಳಿದೆ ಆಮೇಲೆ ಹೇಳಿಲ್ಲ.
What was the IEA?
Also the documents which is already part of this. Along with the
Subject to further consideration in light of the contention raised regarding the impugned order and noticing that is a suit for the plaintiff. There would be an interim order of stay of proceedings in the next date. Petitioner to furnish to do the needful as regards service of notice to the respondent. Petitioner is also permitted to take out notice by way of hand summons and serve the respondent or his counsel on the next date before the trial court. Learned presiding officer to facilitate such service of summons. Next. No, let the you do the service. If they put in appearance, then you move the mat. So if they file wakalat, you move it. You have to pay the process. Yes.
Upesh B.
Yes.
I had appear for petition, my lord.
Yes.
Notice to respond about 2 and 3 may be dispensed with, my lord. They are the co-defendants, my lord. Have filed the application for amendment of written statement. Defendant number
Notice
1.
to respondent 2 and 3 is dispensed with at the risk of the petitioner in light of the submission made by learned counsel appearing through VC. Yes,
My lord, amendment of written statement.
let the other side come.
My lord, interim arrangement was, my lord, there last date of hearing, my lord, interim. My lordship has directed to not to precipitate.
Order dated
Last date of hearing, my lord. May
yes, yes.
Millard, I am the respondent in this case, Millard.
Yes,
Morning, senior counsel had come, Millard. Since matter is listed for process, he went back, Millard. We'll have it in first week of February.
missed the matter in the first week of February.
Second February.
On 2nd of February, the proceeding before the trial court to be deferred till the next date.
applied note.
Each time granted for necessary compliance. Third counsel for the petitioner files legible copies of annexure E and G. Accordingly, the said office objection is overruled. No. Who is the executor of the pronote? Defendant 1 and 2. Yes. Okay, just read. Let's see what the reasoning assigned by the para 5. Yes. In light of the impugned order, it is a case of the petitioner that in light of denial regarding the signature by the defendants, only manner of proof is by referring the matter. No. What is the what are you sought for?
That is the impleading order. It is the case of the petitioner that of the denial regarding signature by the defendants. The only manner of proof is by referring the matter.
Is by obtaining The bank records of defendant number 2. Accordingly, subject to further consideration, will be stay of proceedings of the trial court in the next date of hearing. Issue notice, same order. Now, who's R2?
Is my vendor. Thing is, there's two things what is number 623 of 20, who has been filed by it is the hearing for purchase intent. It is the respondent of one.
I know whether R2 is necessary or a notice can be dispensed.
It could be dispensed. I am the purchaser of the property. I am the purchaser.
No, sir. No, shall we dispense with notice to R2 for this writ petition? In notice as regards R2 is dispensed with as the matter as it is submitted that you are the respondent. Respondent 4. No, only on the process I'm saying. R1 has yes.
So that my lord. I the suit in the way of court of declaration against the same petition. In the year 2018, OS number 25,440 of 2018. And in the meanwhile, he creates third-party rights and executed the sale deed in favor of R2 on 17/9/21. And on 21/9/21, he wrote this. He enters into a registered sale agreement with R4 and R5. So R3 is none other than the brother of R4.
Now, before the trial court, the society is represented by a council. Then why there is no representation in this process? But so they will, no, but they will have to.
And they will know the suit on 25/6/22, the creating of third party. That is the mastermind for all these issues.
No, let the society be represented. We'll hear in their presence. We'll hear the matter.
Because that means so kindly told in the 78 of one section is 8 of when I was able to proceed with rupees. I distributed by the taking the they got to take out of stuff. And work as things. I request your lordship to go to page 78 of the statement of also in the repetition, the photograph which they have filed. And moreover, my representation is the read as filed by the petitioner, only agreement. I get your lordship to discuss. Repetition is the number PMCP. And after cross later, the provision in view of this, the article 227, that is supervised the procedure. Now, however, after kind attention, page 28 of the repetition. Page 28 of the yeah, in terms in view of inordinate delay in passing orders, on the interval.
Paragraph.
33. The auto impugned order is not under challenge. They are seeking direction to the city court for disposal of the application. In a suit for injunction, an application under was filed. To implead these respondents and one another respondent as party. We appeared at the application since the suit is for injunction, there impleading area required. Secondly, one another application seeking action against the society also against the respondent for not participating. The trial court in this issue. Now they want a direction to the in view of inordinate delay in walking order, only by petition under order 13 in PA. Let section of TPC. We initiate contempt proceedings dependent or violating the interim order granted in. So, in all this thing, the matter relates to suit OS number 63 for 2022. This is a suit for bad injunction filed by the petition against the society alone. Though he was aware of the society's sold property income of the respondent woman, who in turn sold the income of the respondent.
Yes, I'll come to you. Let him start. I'll come back.
Sure.
No, just 1 minute. I'll come to you. Let him make. Now you have challenged which order?
File OS 643. So this is just a report.
OS?
This is a report in court and injunction. Thus, the court passed an interim order and is petitioner the plaintiff there was not aware of the subsequent transactions and the third party rights created by respondent number 1. Therefore, it was only against the respondent number 1. Later on, the petitioner came to know about the third party rights created by the respondent and therefore they were an application was filed because to include all these parties, defendants there. And even though there was an order passed by the High Court, these responding number 4 and 5 got all the clearance in a very speedy manner, by using all influence and avenues. But all the clearances had started even though there was an order passed and they started construction 24/7.
No, but
They have come up to third floor.
OS 643
Yes, ma'am.
plaint is at page 113.
Yes.
There is only one defendant.
Society was only given.
What happened to the others?
When we came to know about then this petition filed applications include all these defendants as party defendants, and they also filed Karnataka and appeared before the.
What happened to that? Those applications?
The interim order was passed. Expert interim order was passed in that. Even though there was an order, and this respondent 4 and 5 have stopped it to application.
No, what happened to the Impleading application?
During the process, my lord, they filed after the other side, they represented.
So was it allowed, not allowed, or is pending?
It is pending.
Pending consideration.
And moreover, it's a suit for bad injunction, not for mandatory injunction. If it is a suit for mandatory injunction, certainly there would have some scope for it.
Now what has happened now? What has happened now?
Now, after this, one more suit, the issues are fine. For declaration, possession and mandatory injunction, that's also before the same court.
No, now you are against which order in this present proceedings?
The trial court has not passed any orders on my applications.
Which application?
Application. May I request my lord, need some time to file my objections to the vacating state.
No, just 1 minute. Let me see. What is the direction you wanted when you filed the writ? What is the direction to dispose of which IA?
I filed my objections and.
No, I'm saying, what is the relief you have sought for in the writ? I'll grant you the relief. Direction to dispose of which IA?
Here we come from animal,
Now that order 39 rule 2A has not been disposed of. So I'll direct the trial court to dispose it of. There ends the matter. I'll ask the trial court to dispose it of.
And this petitioner, they are setting a petitioner's property. It has to decide.
So that the trial court will decide. Trial court is seized of the matter. No, that the trial court has already granted some injunction.
In 643, but not in 501.
No, but you have come, you have sought for relief in so far as which OS? 640.
640.
Huh.
My lord, your worship can have this next week.
No, I'm saying what? No, what I'm giving you the relief. You have to dispose of 39 rule 2A. I'll dispose it of.
Again, on the last occasion, it has adjourned this matter to 1-2.
No, that I'll direct. Now I'll direct it. That is the only relief.
This such time, direct this.
No, that you are seek before the trial court. Already there is an injunction.
In fact, the serious petition was made for the same similar case. Our allegation. No allegations were made. Only.
No, that is different. Now the only relief that would survive for adjudication is a direction to dispose of 39 rule 2A. That I'll direct and dispose it of. That's all. Why keep this matter pending? Other reliefs you cannot ask. Other reliefs in a separate writ you can ask. Insofar as the suit 643, I'll pass a direction in this. The petitioner has a petitioner plaintiff has filed the present writ petition seeking for various directions including for that we can't in these process, and that we can't in these process. That all you have to seek for in your trial court, not here.
Trial court is passing any orders.
I'll direct it.
Respondents are taking.
No, that's a
They are on the law.
no, that I'll direct for an expeditious disposal. And petitioners have sought for issuance of writ of prohibition, restraining respondents from interfering with peaceful possession and enjoyment of property and has sought for direction to the respondents to maintain status quo till disposal of the suits, comma, sought for issuance of writ of mandamus to pass orders on the interlocutory application filed by the petitioner under Order 39, Rule 3A, within bracket, should read as Rule 2A, read with Section 151, to initiate contempt proceedings against the defendants for violating the interim order granted in OS 643 of 2022, comma, sought for issuance of writ in nature of mandamus, directing the concerned superior officer above the rank of respondent number 4 in the police department to take action against respondent number 4 for misusing his official power, comma, issue writ of mandamus directing Deputy Commissioner of Police to investigate the matter in a speedy manner and to file report before this court, comma, issue writ in the nature of mandamus directing respondent not to interfere with peaceful possession and enjoyment of the property by the petitioner till disposal of the pending suits. It is noticed that insofar as the present roster is concerned, the only relief that can be considered is relief sought for in Roman 2. In light of the submission that application and Order 39 Rule 2A is pending consideration, the trial judge in OS 643 of 2022 to dispose of the said application expeditiously within a period not later than 2 months from date of furnishing of certified copy of the order. Insofar as the other prayers are concerned, it is open for the petitioner to seek for appropriate relief in the pending suits between the parties before the trial. Accordingly, the petition is disposed of. Yes. That is, there's an order to get it executed, not in these cases. Yes.
Board matter, CN Raju.
What happened to that application? Next. Page?
11, page 26.
Just read from para 7.
On presidential duration, made by the honorable
Para 7, para 7.
Because I agreed to agree. They will note that the degree holder also gets not to be dependent on any manner other than cases or for other reasons. Say the case gone on, the over. Judgment record, fail to vacate the therefore, dialogue. Thereafter, this court has at this stage, judgment record by this that he is undertaken to take all on particular till then the to the evidence no time. The judgment record by the respect of the order. The honorable Court of Karnataka has corrected on the rules of this record. Judgment record has made representative. Not because it won't be further matters need to take a undertaking also on the basis the honorable Court of Karnataka including
Now you serve the other side in his presence. We'll see if something can be. You serve the trial court advocate. I'll have it on Monday. In their presence, if any settlement can be made, we'll try. That's the only relief I can grant. Let him come. You serve the trial court advocate. And Monday, let us see if something happens. We will. What we can do now in October 2022, you are directed to hand over possession. There ends the matter. We'll have it on Monday. You serve the other side. Let us. No, correct, but compromise, how we can extend.
That's why I made that. But in the I want that. I want no, this are the good when I pray for getting that you are not taking that's why I'm passing on.
No, let him come on Monday. Let us see. I'll
more than that, really, our arm of the veterinary doctor was so India. Veterinary doctor was very to arm veterinary doctor
No, but then you will have to settle it with the decree holder.
It's only a message. I don't want to argue much more.
There will be stay of. No, but now what? Num position not ಕೊಡಿ ನೀವು.
No, ನಾನು ಹೇಳಿದೆ. ಏನಿಲ್ಲ ಯಾವುದು ಸಿಗಲಿಲ್ಲ ಅದರಿಂದ ಪ್ರತಿಭಟನೆ ಮಾಡ್ಕೊಳ್ಳೋದು ಮುಖ್ಯ ಆಗ್ತದೆ. That process not disarmable directly. There is no facilities. The trade to
Proceedings in execution are stayed till the next date. Emergent notice, same order. This is the matter on Wednesday. Suit for. Where is that judgment? Yes. Yes. You are not a party to that.
Address in the law is 119 or T2. Kindly tell us to their own schedule in the document law. Or to the bottom of it. All that we said also that we got it. And page number 119 number 32. The correct property replacement. How in the kindly tell us to the schedule hospital of the what they do is 119 or copy is the process. He was given the execution also and it is expired. Service in fact official. In fact, it's not that the type of number should be
You are not served.
Page number 22.
You, what is the matter on merits? You are the owner. You executed the agreement.
Also, I have tried execution after 8 years. Then the execution policy order 21 to 22 and in 2 years, how can we discuss after 9 years, we have tried the execution order. Okay. 250 of 1991 or 2019 there. 8 years, 7 years. What is it getting process? The degree of council award in between the state is second of get notice on the other side. The remote the execution for the place 17. In between the clients are outside. What by oversight record the first to be to kindly see the outside. The 5 minutes now they have come down to them and to pay the professional at the professional. not disclosed. And not legal but mysterious. They are not disclosed or they are not executed.
When did you get notice in the execution procedure? Third counsel for the petitioner submits that fraud has been played on the petitioners insofar as decree is obtained in OS 26/573 of 2013 showing the wrong address. It is submitted that there was no notice served on the petitioners in proceedings before the trial court. It is further submitted that subsequently, on the basis of the ex parte decree obtained, execution 25091 of 19 has been filed after the lapse of more than 5 years. And in such execution proceedings as well, no notice has been served as is required in terms of Order 21 Rule 22, as execution was filed after the lapse of 2 years. Correct. After the lapse of 2 years. It is further submitted that even in the execution proceedings, notice was taken at the wrong address. It is submitted that now what happened to the notice in the execution proceedings?
It to be received case number 20. Publish the correct address. Still the address has not been published and notice are yet to be still in process.
It is submitted that though notice has been ordered, without service of notice, proceedings have progressed in the execution proceedings. And apart from sale deed having been executed through commissioner, delivery warrant has been issued. It is submitted that though there is a observation that despite service of notice, JDR has not appeared. The said observation may not be correct as notice is not served. That is your stand. In light of the allegations, in light of the assertion of fraud, there would be stay of further proceedings in execution 25091 of 2019. Issue notice to the respondents. But are you sure? I mean, you should, in case we find that you have issued received notice, then you'll be in trouble. Yes. One ನಿಮಿಷ ಅದನ್ನು ಓದಿ ಅದು ಒಂದೇ ಒಂದು ಕರೆಕ್ಷನ್ ಅದು ಆರ್ಡರ್ ಓದಿ ಇಲ್ಲ ಮಧ್ಯದಲ್ಲಿ ಅದನ್ನು ಆರ್ಡರ್ 21 Rule 22 అలాంటింత మించింది.
And after lapse of was taken at the wrong address. Stated that no notice has been ordered. And it's not on proceedings of the rest. And apart from that,
Apart from execution of children.
execution of set observation may not be correct. And what is right after the assertion.
Which objections to be complied. Yeah. The counsel for the petitioner filed a memo. In light of the same, petitioners permitted to convert the writ petition into a civil division petition. Full stop. Necessary amendments are permitted. Petition is disposed of for statistical purposes.
By connecting matters with who are converted.
Give it, we'll have it posted tomorrow. Give the number. Adnale, top of the order, top of the orders list. Yes. This court notice has gone. This is the matter next week. Petitioner is also permitted to take out notice by way of hand summons. That is there, isn't it? Agli next week Mumbai Bandaga. Yes. No, the 2 weeks correct. This is the matter. 27. The office objection at serial number 1 is kept in abeyance. Is kept in abeyance for the present in light of the submission made. What about 2? No. Nanjundappa and his family members. So the office objection is Nanjundappa and his family members and Ayub Khan were not parties before the trial court. Then scheduled property to be mentioned at the end of writ. Office objections are kept in abeyance for the present. Yes.
This document now they wanted to insert
ನಮ್ದು ಟೆಕ್ಸ್ಟ್
No, now you take out notice. You take out notice. Let us see.
Once they mark the document.
No. I'll make it clear subject to outcome of this writ petition. Let us.
Once it is marked, it's not a relevant document.
No, that's it. That question of relevancy, you can take it when the document is being marked. Suppose the document is being marked, since it's on record. It's always open for you. That's the trial court also says question of relevancy.
And 1981 said it, at 1982 challenge. Seeking declaration that they are declared that said it at 1981 adopted it and 1980
No, but that's a matter to be of appreciation of evidence. We can't prevent them from marking it. That you object at the time of marking. No, that at the time of appreciation of evidence, not at this stage. You take out notice, I'll say subject to the outcome of this writ. Let's. No, so whether it's relevant or not, only at the time of appreciation of evidence, not even before marking, you can't object. That is at a later stage we can see. If it comes, how you are going to be prejudiced? Let us see. If it's not relevant, it will not help you. Issue notice. The marking of the documents would be subject to outcome of the present proceedings. Yes. Yes. That is the order. Notice is dispensed. Notice is dispensed with respect to respondent 4 to 6. In light of the submission that the said respondents have been placed ex parte before the trial court. First time, no? No representation on behalf of the petitioner.
My lord, item 45 is. My lord,
44. 44.
44, yes.
No representation on behalf of the petitioner. This is the matter to hear regarding maintainability on.
5.
Yes.
45. Hello.
Tomorrow. Huh?
45.
How much time will be required for this? Date close. Huh? 2nd of February.
Last second.
Let us see, on the next date we'll dispose it.
Not to interfere.
Let us see. Next week on date 27. If I file a memo, interim order earlier granted is extended till the next date. It is submitted that by oversight, interim order was not extended on the last occasion.
46.
46, I appear for the respondents. My lord, on the last date, in amendment application, my lord, came to be dismissed. I appear for the respondent. Mr. Matsudan Rao appears for the petitioner, my lord. Last time he took time saying that respondent number 2 is dead, and he has filed an application, my lord, to bring on record the LR of respondent number 2.
We'll allow that. IA, what are the IAs? Which are the IAs? IA 1 of 23.
IA 1 of
Has been
23
filed.
for condonation of delay.
Yes, just 1. IA 1 of 23 has been filed. Seeking condonation of delay of 25 days in filing application to bring the legal heirs of respondent. It is submitted that respondent number 2 died on 9/9/2022, and the legal representative sought to be brought on record to represent the interest of respondent number 2 or the wife and children of the second respondent. In light of the, as regards the said applicants, third counsel, she So and so undertakes to file wakalat,
Already filed.
has filed wakalat. But your name is shown, no? But is it shown in the cause list? Learned counsel Sri. So and so submits he has filed wakalat for the said applicant. In light of the admitted facts, application is allowed. The applicants stated in the application are permitted to come on record and represent the deceased or to necessary amendment to be carried out. So what is the matter?
My lord, this
What is the, you appear for the plaintiff. What was the proposed amendment?
First item it was contended, it is the joint family property. And it was also contended in the course of the village leader that the property. It is for the petition. Page number.
Let us have a look at the proposed amendment, just page.
That this particular property has been back by one Mr. Please and by means of a grant with land. Because what has happened was this.
Page, where is the proposed amendment? Is
Page 1. Most of that we wanted to know. And that is the stand taken by the defendants also in the course of the case. We also say this that initially in the case before the defendants, the property was originally purchased by Venkataya in their 1940. And in that background, that was the stand taken. Subsequently, in the course of the come, that he gets this land by means of an order of the land. That has come in the course of the evidence of the defendants also. And that is what is suggested to me in the course of the cross examination. So what has happened, in fact, this order of the land recently already marked in the I am also contending that there is a property also. That is also marked in the and that is the stand related to how the property is acquired is mysteriously because defendants themselves in the course of their evidence and written statement, they have written. The lordship may tell me go to the written statement file and connect a deed. Next year, written statement file.
next year.
Next year, the written statement file.
Page.
Page 35.
next year.
Yeah. Next year.
Yes.
Yes, last year. Measuring creation revenue is not I don't know. For the self-employed property, it was granted land by the landowner under KSRM KG number 4. Wherein once the legal had filed application on the system. However, the same legal had filed number. The High Court of Karnataka, the same was on the here with the also in zone and for that of so that was the order taken and passed by the land. Thereafter, CRP number 13 is not one of the
This illness order, we have what is equivalent. And in the original suit also, earlier also, my project, the property was purchased in 1940. Subsequently, the land property was granted at that. Controversy in respect of the manner in which the property is acquired. Ultimately, our case is land by the landowner is for the benefit of the family. Whereas they are disputing.
No, so what is the averment in the plaint regarding how the property?
Only said as.
And then why is this required? It's superfluous.
If you say what the records in the course of children, exhibit for the mark module. Land is the and then we could also secure the order of the land. So in that platform, we wanted to make this clear.
Now, what is your objection to allowing the IA for amendment?
Yes, my lord. My lord, the objection is this. Please, my lord, come to the plaint, my lord, first. No, my lord, the plaint is at page. It starts from page 14. At page, my lord. Para 5. Para 6. What they contend is that the suit property was purchased. It was not a tenanted land. In this suit, they initially start with the plea that the suit property was purchased by the joint family funds. That is what they contend. That is found at para 6, last district. The plaintiff submit that out of the suit schedule properties, land bearing number 128 upon 1A, situated at Srirampura measuring 2 acres 17 mutta, has been acquired by defend number 26 for the purposes of distribution of house site, and award has been passed and the amount is still with defend number 26, and this amount is also joint family fund. Plaintiff defendant 1 to 5 are also entered. Now the defendant number 17, 18, 21 and 22 behind the back of the plaintiff and other defendants are trying to take the same from defendant number 26, stating that this property exclusively belongs to T. Venkataya. Since T. Venkataya was Srimati, defendant number 5 herein has got sons T. Varadaraju, so and so, so and so. They all say, and ultimately they say that this property was purchased by us. It is the self-acquired property of our father. Thereafter, what happened was this suit came to be filed. This is the second round of litigation. Please come to the return statement, my lord. Return statement at page.
No. What is the? Where is it said that it's the land was purchased? Where do you get that? I'll come back. Let him finish it. Let's see what. Let me see what is.
Page 22. Page 22, my lord. Page 22.
I'll come back. Where do you get that stand?
Yes, my lord. Managing out of the joint family nucleus, amount given by other brothers, said land has been purchased for the benefit of the joint family. This plea even today stands. Now may I see tell you the background, my lord. Please come to the return statement at page 32. Page 36. Page 36. Earlier, my lord, the mother, that is Madama, the mother of the present plaintiffs, and the other brother children had filed a suit in OAS 512 of 1990. That suit came to be dismissed, wherein a finding came to be recorded that this is our self-acquired property. Please read the return statement amendments, my lord. Page 36. However, the said Dingaya had filed a civil revision petition 3901 in the High Court of Karnataka at Bangalore. Same came to be dismissed on 3/7/1990. Prior to that also, one tenant Dingaya had filed before the Land Reforms Appellate Authority, Mysore in so and so, was dismissed. The grandfather, who was the original propositor, was the absolute owner who acquired the land by way of grant. Does not become the hereditary property, but it was the self-acquired property of respondent 16 to 25, father of original propositors. The other brother, T. Timmaya, has filed a suit for similar relief against defendant 16 to 25 and has utterly failed to prove his case for his one-third share in the suit schedule property by filing OS 512 of 1990 before second civil judge. So and so. The suit came to be dismissed on 21/11/1990 and its judgment was pronounced on 1/10/2007. 1990 suit was filed on the very same ground for the partition and that suit came to be dismissed. In that suit, my lord, the mother and father of the present petitioners were parties. Thereafter, what happened? Said T. Timmaya preferred a first appeal in 349 of 2009 in the Court of Fifth Additional Judge, which was dismissed on 1/4/2010, confirming the decree and judgment of the trial court. Furthermore, LRs of T. Timmaya again has approached Honorable High Court of Karnataka in RSA. That was dismissed. This was dismissed, my lord, in the year 2011. Immediately after the dismissal of the suit, they set up the daughters of the house. In the suit, my lord, please see the plaint. Please come to the plaint, my lord. At page 40. This is the second round of litigation of this very property. Who are these petitioners? Petitioners are Manjula, Jhansi, and Puttamani. These are the three daughters. Now, Madamma is the mother. Now, Madamma, now the person who is dead and whose LRs are brought on record are mother, brother, and this thing of the petitioner's theory. Now, these people are set up in this second round, and Madamma was a neo-nominee party. Jauravaya was a neo-nominee party in the earlier suit, which saw it end till the second appeal before this honorable court. Thereafter, they file a suit. In the suit, I trace entire thing stating that no, this is not the joint family property. This is the self-acquired property. All earlier proceedings have been held that it is my self-acquired property. Now, these three persons are set up. And in the plaint, they say that it is the property purchase. That please still goes on record. Please see page 22, my lord. Plaint. Now, they want to take a mutually contradictory plea to say that no, this is the land, my lord, granted. The grant of occupancy right has attained finality in the earlier proceeding, to which the mother of the present petitioners were a party. The trial court records everything and dismisses it. My lord, one judgment of your lordship that mutually contradictory pleas cannot be taken in amendment, particularly the plaint. This para 6 at page 22 continues to be on record. Now, mutually contradictory pleas sought to be raised by virtue of an amendment after the closure of the evidence. The evidence is closed. After the closure of the evidence, my lord, plaintiff files an application. Plaintiff does not cross-examine us on any of the issues which we had stepped into the witness box. Now, plaintiff's evidence is over, defendant's evidence is over. In 2019, my lord, at the time of my lord argument, an application is filed on the ground that it is my defense, that it is the granted land, it was the self-acquired property of my father. Can my defense be the reason for an amendment, my lord? Now, your lordships have held in 2009 volume 2 SEC. My lord, so far as amendment of the plaint is concerned, my lord, may read that, my lord, I'm handicapped, I'm unable to share the judgment to your lordships. 2009 volume 2 SEC page 409. This judgment is relied upon by the trial court. My lord, I will read this judgment, para 10 onward. By reason of Civil Procedure Code Amendment Act, Parliament inter alia inserted proviso to Order 17 of the court, which reads as under, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that, in spite of due diligence, party could not have raised the matter before the commencement of the trial. This is the second round of litigation which is going on. Now, next para. It is couched in a mandatory form. Court's jurisdiction to allow such an application is taken away unless the condition precedent therefore are satisfied. That is, it must come to the conclusion that in spite of due diligence, the parties could not have raised the matter before the commencement of the trial. I have stated in the plain what is the source. Now, please come to para 11, my lord. I will read it and then. From the order passed by the learned trial judge, it is evident that the respondents had not been able to fulfill the set precondition. The honorable, now, this judgment has been relied upon by the trial court. Please come to the trial court judgment, my lord. Why the trial court has disallowed the amendment application? Please come to para 13, my lord. Para 13 of the trial court judgment. The judgment which is referred to by me is referred to at para 12 of the trial court judgment, page 55. Page 55, my lord. They have placed one more decision of the Honorable Supreme Court reported in 2000 in Vidyabai's case. That is the judgment which I relied upon. Para 13, the court assigns reason. As stated supra in their pleading, plaintiffs have taken a contention that all the suit scheduled properties are undivided family properties of themselves and defendant. Now, by filing the instant application, plaintiffs are intended to plead first title to the suited properties was granted in the name of T. Venkataya under occupancy rate for unbearable. But as discussed earlier, evidence of the plaintiff side is already concluded and PW1 was fully cross-examined. Thereafter, one more application was filed seeking permission to produce additional documents. It came to be allowed. For the sake of this, IF1 was carefully gone through certain admissions given by PW1 in the course of her cross-examination. PW1 is none other than the first plaintiff hearing, and she herself has sworn to the affidavit annexed to the instant IA. In her cross-examination, she deposed that first title issued property was purchased by her grandfather T. Timaya, but she does not know from whom and when she purchased the same. She had not produced any document before the court. It was further suggested to her that one more proceeding was initiated at the instance of Ningaya for grant of occupancy right, but she pleaded ignorance. Now, it is clear that earlier the stand of the plaintiff was altogether different, and it was a definite case that first item was purchased by their grandfather. Now they are intending to plead that with respect to first time suit properties, occupancy right was granted to T. Venkataya. Now, that plea is not to be taken out of record. It stands. A plaintiff cannot have a mutually contradictory plea. And it is not as if that whatever stated in the written statement was not within their knowledge. And the Honorable Supreme Court has time and again has held that the amendment to be allowed for the basis for amendment to be allowed for a plaint is different from basis to allow the amendment for a written statement. Plaint, my lord, easily amendment cannot be allowed. Whatever the stated in the plaint, my lord, would continue to be on record unless, my lord, as held by this honorable court and the Honorable Supreme Court, that they make out a case for amendment. It is not a new thing. I can understand, my lord, if it is the first round of litigation. This is not the first round of litigation. I have stated the entire history, my lord, in the written statement without suppressing anything. Plaintiff should have been fair enough to state about the first proceeding. The second proceeding, otherwise is hit by res judicata. Madama was a party to the suit, earlier suit. And the person who is dead was a party to the earlier suit, whose LRs are brought on record. Now, the earlier suit, my lord, saw its fate up till this honorable court, my lord, in a regular second appeal, where it has been categorically held that that is the self-acquired property of the petitioner's hearing. My lord, the cost of repetition, whatever I have stated, plaintiff should have been fair enough to state, my lord, in the plain about the earlier proceedings and their right to file a second suit. This suit came to be filed in the year 2013. The trial judge, my lord, demeanor of the witness, that is why, my lord, the trial court, the witnesses, my lord, examined before the trial court, where the judge would have had the benefit of seeing the demeanor of the witness. My lord, the honorable judge who has seen the demeanor of the witness, who has seen the pleadings of the parties, my lord, has refused to, my lord, allow the amendment application with cogent reason. My lord, in a writ petition, the said amendment, the said order is sought to be challenged on the ground that no, it is only an explanation. It is not as simple as that is placed before your lordship. Earlier suit, where all parties were aware of the family factors. That is why, my lord, the Honorable Supreme Court, my lord, in 2002 has categorically held what is the purpose of amendment to Article 6 Rule 17 by virtue of 2002 amendment.
Yes, we'll continue tomorrow. We'll continue tomorrow. We'll continue tomorrow.
Yes, my lord. I will take two other judgments tomorrow, my lord.
We'll use the matter tomorrow.
That's serial number 52, my lords.
Tomorrow.
Interim order needs to be extended, my lord.
Order extended till the next
tomorrow.
Matter tomorrow in the same stage. Yes. Other matters, please take dates from the court officer. I have to. That you ask the court officer. I have to raise all wherever interim orders are there. It will continue. Next date, please seek for a date prior to the date fixed in the trial court. Otherwise, everything if you have tomorrow, nothing will reach.
Certainly.
That you ask, I told the court officer, depending on it, dates will be given.
Sir, court officer. Hello. Hello, court officer. ಇಲ್ಲ ಇಂಟರ್ ಮಾರ್ಟರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿಸ್ಬೇಕು ಬನ್ರಿ ನಂಗೆ ಡೇಟ್ Court officer serial number 52. Sir, court officer.
ಕೇಳಿಸ್ತಾ ಇದೆ ಪ್ರಜ್ವಲ್ ಸರ್ ಹೇಳಿ ಎಲ್ಲ ಹೇಳಿ ಸರ್.
Serial number 52 interim order extend ಆಗ್ಬೇಕು ಸರ್.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆಯಾ ಸರ್ ಅದರಲ್ಲಿ?
ಇದೆ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ವರ್ಗು ಅಂತ ಇದೆ.
ಸರಿ ಸರ್ ಆಯ್ತು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ. ಓಕೆ
ಡೇಟ್ ಯಾವಾಗ?
24th
ಬೇಡ ಸರ್, ಊರಲ್ಲಿ ಇರಲ್ಲ 30th ಕೊಟ್ಬಿಡಿ.
ನೀವು ಬೇಡ ಅಂತೀರಾ, ಅವ್ರು ತಗೊಳ್ಳಿ ಅಂತಾರೆ. ಯಾವ್ದು ಕೊಡೋಣ ಸರ್?
ಅದರ್ ಸೈಡ್ ಇದ್ರ
ನೀವು ಅವ್ರ ಆಪೋಸಿಟ್ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ಸರ್ ಅಷ್ಟೇ.
24th ಯಾಕೆ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಓಕೆ ಸರ್ ಆಯ್ತು.